Hello and a warm welcome to Federal Special Program Capital Beat. The key provisions in the Waqf Amendment Act, which sparked nationwide protests, have now been paused by the Supreme Court. It flagged some of them will lead to arbitrary exercise of power. Now, this was a bench of Chief Justice Justice B.R. Gavai and Justice A.G. Masih, and they said that it found no case was made out to stay the whole statute, but some sections that need some protection. Now, these provisions have been paused till the petitions challenging the constitutionality of the Act are decided. Now, what are those provisions? Let's go one by one. Now, flagging the sweeping powers granted to a district collector in the new law, the court said that the collector cannot be permitted to adjudicate the rights of personal citizens, and this will violate the separation of powers. Till adjudication happens by the tribunal, no third party rights can be created against any party. The provision dealing with such powers to the collector shall remain state. That was one point. Then they also said that the new law had empowered the district collector as the final arbiter in issues related to the Waqf property ownership, where the collector in his report mentions that the property wholly or in part or in dispute or is a government property, the Waqf in relation to such a part of property shall not be registered unless the dispute is decided by a competent court. The Muslim bodies protested against the act, and they had flagged this provision and said it would lead to a surge in illegitimate claims on Waqf properties. The bench also said that not more than 3 non-Muslim members should be included in a Waqf board and not more than 4 in the Central Waqf Council. Chief Justice Gavai said that the clause in the law that said only a person practicing Islam for at least 5 years may declare a Waqf must also be paused. So this was another stay on the key provision. Without any mechanism, he said, it will lead to an exercise of arbitrary power. The court also noted that its presumption is always in favor of the constitutionality of a statute, and an intervention must be done only in the rarest of rare cases. So we'll try and understand what this Supreme Court interim order on the Waqf Act means. And mind you, this act or the whole statute per se has not been stayed, but only the contentious provisions for which the lawyers, activists, opposition parties were on the streets, they protested, they signed petitions. So those key provisions have been stalled by the Supreme Court until the constitutionality of the act is not decided. Joining me this evening is Anas Tanwir, who's a lawyer in this particular case. He was there in the court today. Anas, thank you so much for joining. And what does this order mean for you as an activist, as a lawyer who was fighting this case? What does it feel like?
Thank you, Neelu, for having me. This feels like a victory because the court, when they started
victory with a partial victory, Anas, victory or a partial victory?
Partial victory, because see, understand, it is an interim order. Our complete victory will be when we are able to convince the court on the constitutionality that these provisions are unconstitutional. When Justice Gavai started pronouncing this order today, the first thing that the court said was that only in the rarest of rare case, because there's a presumption of a constitutional validity of a statute, only in the rarest of rare case does the court intervene, will the court intervene. And the court has intervened. So the rarest of rare case has been established, that the absurdity of the law to have, for example, let's take this provision of 5 years practicing Muslim can create Waqf. How do you determine who is a practicing Muslim? What is the definition of a practicing Muslim? So provisions like this, then giving the immense power to the collector, or even having if you read the provision, while Mr. Tushar Mehta, the learned Solicitor General, he said that only 3 and 4 will be in the Waqf Board and Waqf Council respectively. But if you look at the provision, the numbers come up to at least 12 out of 22. So all of these provisions that were most draconian, that would have changed the course of Waqf in India, have been stayed. There are few things we would have expected a lot. Maybe we were not able to convince the court on that.
Right.
We must take the blame as lawyers that we may have failed to convince the court on that. But
But
we overall we have a good.
you said, Anas, you said that you were expecting more from the court. Now, what were those counts on which you feel that maybe the court has not been able to come up to your expectations? What are those points? What are those gap areas which you still feel that the court maybe could have looked into?
See, first of all, this matter is still sub judice. The commenting on that may not be very fair. One aspect that that I see on social media and everywhere, especially in the Muslim community, is the waqf by user has not been stayed. The provision ending the waqf by user has not been stayed. Now that is, I understand, is little problematic for the community if you look at it in isolation. But if you look at it in two aspects, that even this provision, this act does not have any retrospective effect on the Waqf. And if the new Waqf are being created, it is more than welcome that these Waqf are regulated, they are registered, there is a Waqf deed. Now, we understand that 100 or 200 years ago, or even 50 years ago, we may not have been positioned to prepare a Waqf deed, pay a lawyer, get it registered, and all that. But today, most of us are in that position, and I really hope that the government makes this easy and not make it a hurdle for registration. And that is my understanding. If on Waqf by user, if the court could have stayed, it would have been a bigger victory. But even that does not really harm us. And even for the old Waqf, if their nature is to be changed, if they are to be dispossessed, denotified, that is also to happen through court. And we have immense faith in courts. There is no doubt about it. We have immense faith in court. And the court has said that not just Waqf Tribunal, but High Court. You go until High Court, and when they determine, and High Court is a constitutional court. So we will abide by that decision. There will be individual battles. There will be individual battles. I can see that happening. Right. But overall, it is a victory. It smells like victory. It feels like victory.
Right. So you do feel that this is a partial victory, and of course, the end goal would be to establish the unconstitutionality of it as well. But what are the challenges? And since the SIR case is very, very late, new, and it's happening in the court. Now, in the case of SIR, though there is no comparison between the two, I must admit, but the way instructions by the Supreme Court were not followed on the ground, say, for example, in case of BLOs were not given clear instructions by the ECI. Supreme Court ultimately had to tell the ECI that please put down the instructions in black and white so that the BLOs can follow the instructions. Likewise, do you think that in case of no clear instructions and a random order that, okay, the certain provisions of the act have been stayed, how do you think now that the collector will respond, or the people on the ground will respond to a situation like this? Because earlier there were transgressions, there were violations, people were functioning in an arbitrary manner. What is the guarantee that despite the court order, things will fall in place? And is that not a challenge?
See, again, as you yourself said, these two are very different cases. The mechanism is completely different. There is a rule of law. We believe there is a rule of law. And if the Supreme Court has stated certain provisions or has curtailed the power of certain institutions, certain officers, or the executive, let's take the executive, they will have to abide by it. Not abiding by it will give a cause for contempt of the court. So I don't think any officer would like to be called to court in contempt. So I think if the court has stated the provision, those provisions will not be given effect to. And if the court has curtailed the power of the executive will not overreach, the executive will not exercise the power it doesn't have.
Right. But this stay on the key provisions, Anas, would you not see it as something where Supreme Court again has, in a way, upheld the rights of the minorities, upheld and looking at the fact that the way minorities have been targeted, their properties were targeted, Do you think that it comes as a big relief for the minorities? It comes as a hope also for them that, okay, the government doesn't stand by them, at least the courts are there by their side.
Yes, of course it does. See, we have had, there have been time when if I speak as a member of the community, from a Muslim community, there have been occasions when we have been disappointed. Okay, and I'm not saying this as a lawyer. All right. But as a member of the committee, we have been disappointed. But we must also remember that this court has time and again, even in the time when we feel the democracy is threatened, the institutions are under pressure, even then we have had good order in mob lynching cases, we have had good orders in hate speech cases, we have had a very good judgment by Justice Gawai only in bulldozer cases. And then we have, we have had series of victories. So this is also in that line only. The court has, we criticize the court when it has to be criticized. We criticize the court when it falls short. But we must also praise the court when it stands by the last man, when it stands by the minorities, or most important, when it stands by the rule of law, when it sees the law as it is. And this determination, if you read the judgment, the court has been very careful. It is a very good balanced order. They have done a balancing act. If we are claiming victory, we are claiming victory only because there is a presumption of constitutionality with the state, with the union. And despite that, we have some stay. Otherwise, it is a very balanced order. And we must praise the court for that.
Anas, do you think that this case also has larger ramifications on other on other cases as well? Looking at the fact,
I don't know. See, larger ramification on the how the Waqf properties will be, protected, how they will be dealt with, handled with. All those things, administered rather, all those things are there. They are larger ramification, but I don't think there's any ramification on any other pending case. The Supreme Court is not one.
When I'm talking about ramifications, say for example that the power of the collectors have been curtailed, and in many other cases, not only in Waqf property but in several other cases where collectors have been functioning in an arbitrary manner. What does it mean? Does it not have this particular order? Does it not have a larger overtone beyond what is happening with the Waqf properties? Of course, this order is in relation with the Waqf, but the collectors working in an arbitrary manner, does it have a larger overtone to it as well?
See, it was only the issue of Waqf, to be honest, before the court. The court has ruled only on the issue of Waqf. There can be larger ramification. If the Supreme Court is giving an order, it obviously has a nationwide ramification. And wherever, and in past also, wherever excessive power has been given to executive, the court has always balanced that. There is a separation of power. The court understands that, and executive cannot be given a free hand. We are a country that is governed by constitution, by the rule of law, and executive has its own power, but that power cannot curtail the fundamental rights of individuals or communities. Right. So yes, in that aspect, there will be ramification. Otherwise, this was only, the order is with regard to the Waqf cases only.
Right. Now, I want you to go one by one, the various highlights of today's, and I'll go one by one, the points which Supreme Court has mentioned. Now, first is the stay on 5 years of practicing Islam provision. Only 4 non-Muslims in the Central Waqf Council. I want you to really explain now to the audience, which has not maybe followed the earlier case, and now how does he understand that this order is very significant for the Muslim community?
All right. So what the court, for the first part, the 5 years, what the Act says is that only a person who is a practicing Muslim for 5 years can constitute a Waqf, can give endowment to Waqf. Now, the problem with this is, and that's what court has also observed, that there is no mechanism to determine who's a practicing Muslim. This is completely arbitrary. And how will you devise a scientific and constitutional mechanism to determine if someone is a Muslim, practicing Muslim or not? Not just practicing Muslim. How do you determine someone is a practicing Hindu or a Christian or a Sikh? Religion is very personal. My identity is of a Muslim. I believe in one God. I'm a monotheist. I believe in Islam. I'm a practicing Muslim. So if I'm not praying 5 times, does it make me any less of a Muslim? This is the determination that is to be made by Allah Himself and no one else. The government cannot go into the determination who is a better Muslim, who is a worse Muslim, who is a practicing Muslim, who is not, or who is a non-practicing Muslim. There cannot be a constitutional mechanism for this. Second part was your question with regard to there's members in the Waqf board, the non-Muslim members. So if you read what Mr. Tushar Mehta, Solicitor General, said that there will be only 4 and 3 respectively in Waqf board and Waqf council. But if you look at the act, out of 22, 12 could have been non-Muslims in the Waqf board. So based on what Mr. Tushar Mehta argued and gave a sort of an undertaking to the court that there will be only this and this, and the court looked at the provision, so court capped it to 3 and 4. That has been on the basis of the argument that the Waqf board specifically performs not a religious function but a secular function. We will be arguing against this when the matter is heard on constitutionality, but as it stands, now the majority cannot be a non-Muslim. Majority will be Muslims. We still believe that there should not be a non-Muslim in the Waqf board or the council for a very simple reason that every temple, every big temples or Gurdwara, they have a separate mechanism. There are no non-Sikh or non-Hindus. Matter of fact, Mata Vaishno Devi Shrine Trust Act says that if the Lieutenant Governor is a non-Hindu, he will have to delegate his power to a Hindu. In a other temple act, in a certain temple act, it has to be a Vaishnav. Very recently, before the court, this was the question that if we are making a receiver or a observer to some temple, it has to be a Vaishnav or performing these things and believing in these things. So the law, the constitution gives us the right to administer our properties. It's a fundamental right of the community. It's a fundamental right of the individual.
Right.
And that for administration of that fundamental right, the community will do it and not a non-Muslim. As simple as that. That will be our argument and more before the court when it is heard on constitutionality.
Right. No, but CJI Justice Gawai said that the law presumed constitutional and the entire Waqf Act has not been stayed. Now, your ultimate battle is to also establish that the act is unconstitutional. So of course, you got a partial victory today because 3 provisions, or rather the 3 clauses have been stayed. But what about the ultimate unconstitutionality of the act? That still remains a challenge before everyone.
I must clarify that presumption is with regard to interim orders, with interim stay. The presumption is not for the final hearing. At the final hearing, it is all open. We had a more difficult task as far as interim stay was concerned. We have our task a little easier when it comes to constitutionality.
Right. Do you also see this as a setback for the majoritarian agenda where, and of course, the power of balance? Supreme Court is trying to bring in that power of balance where everything, it seemed, was tilted towards the non-Muslims and not towards the Muslims. So does it bring back a semblance of balance? And also, is it a setback to the majoritarian agenda?
See, it is not a setback to non-Muslim community. Okay, it is a setback to the government. It was not a battle between Muslims and non-Muslims. It was a battle of constitutionality. And in that battle of constitutionality, in the first battle, we have in a way emerged victorious. Going forward, we will look at it. It is obviously a setback for the government because despite the presumption, there is a stay. And going forward, we will argue better, hopefully, and convince the court on the unconstitutionality of furthermore provisions.
But all that narrative, you remember that, such and such a mosque is at risk, and that kind of a narrative which was being played out. And coming as it does, the stay also is coming right before the Bihar elections. What do you think could now be the political narrative? according to your sense?
See, today I'm speaking to you as a lawyer of the petitioner. And for me to comment on political narrative will not be fair. But my understanding is that obviously this will have a ramification in India, especially because the way this was brought in, the way this was celebrated by a section of the government or the party, that has obviously received a setback. And that setback going forward to in the elections may have some ramification. I'm really not an expert on this.
Right. All right. So, and my last question to you, Anas, is that so in entirety, if you look at the interim order of today, it comes as a big relief or it comes as a big victory, and there are several parties who are taking credit as well. Congress is also taking credit. The Muslims are also taking credit. Everyone has jumped that it is because of us we were on the street, and because of which because of that pressure, Supreme Court was forced to listen to our prayers.
See, I mean, I can't stop anyone from taking credit. Everyone will take credit. There were more than 140 parties before the court. So there are at least 140 people who have a legitimate claim to this victory. It's all right. It makes no difference. People must celebrate. This is a victory and it must be celebrated in that manner. A lot of time we do not celebrate our victories. We want more, we want more, we want more. And that brings in a sort of a negativity in the narrative and in the among the people also. So this is a moment where if everyone wants to celebrate, everyone should celebrate. I don't think protests had any impact on the court hearing. At least in this juncture, it did not have any impact. But yes, we must credit all the lawyers, all the senior lawyers, Mr. Sidbal, Mr. CEO Singh, Mr. Uzaifa Anadi, Mr. Sanjay Hegde, Dr. Rajiv Dhawan, Mr. Amal Shamshad, and other lawyers who appeared in this matter. The AWAs like us, many AWAs like us, many assisting counsels, and all of those deserve credit in this. It was handiwork of the lawyers in the court, and parties were obviously. I represented two Congress MPs, and Mr. Asad Owaisi's petition was also there. There were other political parties who had come as a party before the court. So they also have a right to. In fact, the judgment reads as in re the constitutional challenge to Waqf Amendment Act 2025. All right. So it is. I mean, everyone can seek credit in that case because it is not in name of one individual or in name of one person. It was a collective effort by the lawyers and the parties, and I congratulate all of them.
All right. Wish you all the best, Anas. Thank you so much for joining on the Federal.